Welcome, everybody, to today's CLE webinar as part of the WashU Law School AI Policy Series, where we cover the most cutting-edge issues in AI. We're very fortunate to have here today Adam Lawton. He's a shareholder at Greenberg Traurig LLP in Houston, where he advises healthcare providers and healthcare businesses on complex transactions, regulation, and compliance matters. And his practice focuses on healthcare transactions as well as M&A, joint ventures, licensing, and payer enrollment. In today's session is HIPAA privacy and security compliance, fundamentals and emerging risks in the age of AI and technology. And without further ado, I'll pass it to Adam to present here today.
Good morning, everyone, or whatever it is when you're watching this. Happy to have you join us. So I appreciate the introduction and the opportunity to speak with all of you. Today we'll be talking uh, about HIPAA and the way that it interacts with AI. And so I wanted to first talk a bit about, what HIPAA is in general. I realize, everyone listening to this may not be in the healthcare field. And so, HIPAA is one of those things that you do whatever kind of law you hear about at dinner parties, and people say things like, well, I can't tell you that because of HIPAA. And most of the time that's not true. So we'll talk a little bit about those rules and what they mean, because that's really going to set the predicate for talking about AI and its interaction with HIPAA. So, just by way of background, and it hopefully won't spend a ton of time on this. So, there is a HIPAA statute, and one of my favorite things and ways to lead off presentations like this is to explain that the number one way to totally demolish your credibility as it relates to anything with HIPAA is to spell it with two P's and not two A's. It's a mistake that all of us have made at one point or another. But the minute you put the two P's there, anybody who knows anything about HIPAA will immediately say this person is not to be taken seriously. So the HIPAA statute, which was passed back in 1996 and was kind of the remnants of whatever was left over after Clinton Care. It doesn't, people say, oh, it stands for Health Information Privacy and Something Act. And it doesn't. The HIPAA statute really had little to do with health information privacy. It's actually Health Insurance Portability and Accountability Act. But the only thing that anybody remembers out of that, and the thing for which HIPAA has become known ever after, is the health information privacy and security part. And that's really the function of the HIPAA rules, not the statute itself. The statute says virtually nothing except we're going to have these rules and provide some definitions around that. But the three main rules are privacy, security, and breach notification. We'll talk about each of those because they're all trying to accomplish different things. In looking at how these rules have evolved, I throw this up here and I won't read through all of it because folks can see the slides. But I think what I want to emphasize here is that the changes in the privacy and security rule are relatively infrequent. You have a statute, like I said, 1996. Then within the next 7 to 9 years, we have the initial versions of the rule emerge. They get updated in 2009, which was really part of the Affordable Care Act. Then in 2013, there's a pretty fundamental rewrite, which we call the omnibus rule because it sort of touched everything. Then another 11 years passes, and after the Dobbs decision, we get the reproductive health rule, which I'll talk about briefly later on. And then just last year, we had uh, what seems like a pretty significant revision to the security rule, and that's going to play into a lot of the things that we're talking about here in terms of technology and AI. But I think the overall scope of what I want to convey is that these rules are not getting changed very often. And as a result, the degree to which the HIPAA rule keeps up with the prevailing technology, much less the bleeding edge of technology, is it's not a very tight relationship. Usually, HIPAA lags quite a bit behind the current state of technology. You know, I know cryptocurrency is still a thing, and just in general, the whole idea of blockchain was very popular, maybe 4 or 5 years ago, and nobody ever updated HIPAA because of that. And now it seems like, to some extent, outside of the cryptocurrency world, the sort of blockchain thing has moved on, and HIPAA never bothered to address it at all. And I would say that's more emblematic than it is unusual. So to understand these rules, there are a couple of definitions that we should cover. There is a privacy rule, there's a security rule, there's a breach notification rule, but they all rely on some common definitions. And the most important of which are these definitions of covered entity and business associates, which are the entities that HIPAA applies to directly. And this will become important. Well, it's important for everything related to HIPAA, but it will become especially important as we get into the discussion about AI. So um, covered entity, the basic scope of those entities that are required to comply with HIPAA. HIPAA does not apply to every entity that has health information on you. It does not apply even to all healthcare providers. Covered entity, there are three main divisions. Division one, health plans. That's pretty easy. Division two is healthcare clearinghouses, which is a category that no one cared about until about 2 years ago. If you've heard stories or maybe you got notices in the mail from businesses or your healthcare providers about a breach at this entity called Change Healthcare. Change Healthcare was a clearinghouse. And like I said, nobody cared about healthcare clearinghouses until Change Healthcare had a hacking incident and they were locked down. And so now everybody cares about healthcare clearinghouses. And then the final category, probably the most common for most of us, whether we're in the healthcare industry or not, are healthcare providers that transact uh, protected health information in electronic transaction. It's a bit of a mouthful. It's not all healthcare providers. So what the last part of that definition, meaning that they transact protected health information in electronic transactions, means if you go to a doctor, let's say you're from a very small town, you go to a doctor, that doctor doesn't have computers. They have a filing cabinet over there in the wall, and all of your medical records are on paper in that filing cabinet. And along with that, they don't file any claims electronically. They fill out a paper claim and they put it in the U.S. mail and send it to the insurance company to get it. They get a check back. If they do that, and then admittedly that's very rare, probably non-existent, that provider would not be subject to HIPAA because they do not transact any uh, exchange of data using protected health information. Even though they are a healthcare provider, they might be subject to state law, but they are not subject to HIPAA because there's no nexus with interstate commerce because they're not sending things out electronically, and that's sort of the hook that HIPAA relies on. The second big definition is business associate, and this will become even more clear as we get into the discussion of AI and technology. So business associates are entities or businesses that do work for covered entities and as part of that work use protected health information. Classic example of a business associate would be a billing company. So you have a doctor's office. The doctor's office doesn't do their own bills. They send information to the billing company. The billing company then compiles that data into bills and sends it off to the insurance companies for payment. That billing company is a business associate. They do work. Well, first of all, they are not part of the covered entity's own workforce, which is excluded from the definition of business associate. They do work to provide services to the covered entity. And as part of those services, they necessarily utilize protected health information. Now, to use another example, there are groups that will do work for you that do not necessarily involve protected health information, or they may have access to it, but the access is really incidental to the services they provide. The key example here is something like a janitorial service. So a janitorial service, they come at night, they clean up your space. They may, in the course of cleaning up your space, there may be medical records sitting out on the desk, and they may sort of move them, stack them up, and make it look neater. But they are not using the protected health information in order to perform their services. It's incidental. They are totally indifferent as to whether the piece of paper they picked and stacked up is a medical record or is a copy of this presentation. Doesn't matter to them. So they are not a business associate. Now, we'll talk about this more later. Your AI agents that are using, if they are getting in and accessing your medical records in any way, then that AI platform agent, whatever, would be a business associate, and you would need a business associate agreement, which we'll talk about some more. HIPAA rules are meant to protect confidentiality and integrity. Confidentiality sort of explains itself, meaning the people who have access to it, the people who ought to have access to it, and not other people. But it also protects integrity, and this will also become key when we talk about AI a bit later on, because integrity means that when you put the data there, the data is and remains the way that you input it into the system, that it doesn't change, that it isn't being manipulated, or that you're not losing access to it somehow. That is integrity. It's different than confidentiality, because something can remain confidential on your system, but if you lose access to it, if you are locked down, if it gets changed by someone, even if it's someone within your organization, then it has lost integrity, even if it has not lost confidentiality. So there are two things. There's a similar dynamic going on with use and disclosure. So use, HIPAA limits both. Particularly the privacy rule regulates use and disclosure. So the easiest way to think about this is use means the use of the data within your organization. Disclosure means the use of data outside your organization. And the reason I say that HIPAA regulates use is because there have been examples. There was one several years ago. It was a hospital out in California, I think somewhere near Hollywood, and it got a lot of business from celebrities. And there was an internal investigation, and what it found was that there were people on other floors of the hospital who were not treating these celebrities, who would just go poking around in the electronic medical record system to see if they could see, oh, is Brad Pitt here? What did he have done? Or, pick some other celebrity. Oh, they just had a procedure. So they were using it. It never left the entity, but they were using it without authorization. And that was a HIPAA breach, regardless of the fact that the information never left the entity. These people were just accessing it and using it for their own personal reasons without any legitimate need for the data. Minimum necessary is exactly what it sounds like. When you use protected health information, you need to use the minimum amount that you need to accomplish the task. So if you just need to send a bill, you do not need to send them the entire medical record. It's just the information that is relevant to build that claim, which is necessary. If someone asks for, can you send me the MRI that was done on February 18th? You don't send them every MRI the patient has ever had done. If they ask for that and it's for a legitimate treatment purpose, you can share it, but again, you share the minimum amount necessary. And then finally, protected health information or de-identified health information. These are somewhat complex. Protected health information just means information about your health that can be tied back to you as an individual. And there is a list of identifiers, and it includes not just the things you would expect, like your name, social security number, your address, your date of birth, things that we would all consider to be identifiable, but it includes other things that can be attached to your medical record and make you identifiable, like your license plate number or a URL or a driver's license number, something like that, which we don't typically think of healthcare providers retaining, but sometimes they do. De-identified health information, the reason we draw this distinction is there are a lot of things that you can do with de-identified health information that you are not allowed to do with protected health information. And we will come back to this conversation when we get to the discussion of AI. But in order to de-identify health information, you have to take all those identifiers out and you render sort of a record that is a record of someone's health. But not only does the record not contain any identifying information, but it does not contain any information that could be used if someone had access to a different database to re-identify. So, for example, one of the things I think the logic, the way that this tool works is they said, okay, we're going to take away all the identifying information and we're going to give everybody a number as an alias. We'll call this medical record 1 or patient number 1 or patient number 5. But if there is some other spreadsheet that lives on some other system that says patient 5 is Adam Lawton, that is not de-identified, because if that person had access to that spreadsheet, they would be able to identify me, even though the information itself does not identify me. And what I'm trying to get across here is that de-identifying data is really hard and it's a pretty high bar. And that will be relevant in the AI context for some uses of AI. And also that de-identifying data to some extent may render it useless or maybe less useful than it could have been because you don't have any information about who this patient is. It's just raw information about health. So in the aggregate, it may be useful in some sense, but in treating any particular patient, it is not useful. So turning now to the privacy rule, the default under the privacy rule is that there can be no use or disclosure of protected health information unless either an exception applies or the individual whose PHI it is authorizes it in writing. So authorization sort of cures a multitude of issues, but there are other exceptions, which we'll talk about here briefly, which do not require your authorization, or you may sign some papers at the beginning of a relationship with a provider. Lots of us had the experience of going into a doctor's office, probably for the first time, and being handed, a clipboard with a stack of papers this thick, and some of that is HIPAA paperwork, and you fill it out, and it sort of allows them to do a lot of things, even if you were not authorized a specific use in that paperwork. Permitted. So this is what I was referring to when I said exceptions, permitted uses and disclosures, these do not require authorization. And I don't think we need to go into all of them. The one that I want to call out in particular here is TPHCO, which is an acronym, for those of us who work in the healthcare and HIPAA space, stands for treatment, payment, and healthcare operations. About 75 to 90% of what your healthcare providers do with your data falls under this exception. So here I'm referring to, let's say you're a woman and you're pregnant and you go to your OBGYN's office for regular checkups. And then your due date finally arrives, you're going to go to the hospital and you're going to be admitted to labor and delivery. The L&D department at the hospital may go back to your OBGYN's office and say, can you send over the record for, this woman because she's here to deliver her baby? Your OBGYN's office can send that record over to the hospital because that is for your treatment. That's a legitimate use. They don't have to ask your permission. They'll probably ask you who your OBGYN so they can ask the right one, but your OBGYN can send over all those records because that's necessary to treat you as a patient. Using it, your doctor doesn't have to ask your permission every time they open up your medical record when you come for a visit. They're doing it, they're using it, again, internal use. For treatment, it's fine. Payment, same thing. Um, you know, they want to send a bill to the insurance company that provides health insurance for you. That's accepted. They don't have to ask your permission. They may ask your permission to bill a claim for services they provided to you and make sure you want to use your insurance. But they don't need your consent to send them protected health information. The protected health information would here, in this case, would be such and such individual, with this name and plan number and beneficiary number came to our office on such and such date and received this service. That's protected health information. It's about you, it identifies you and relates to your health. What sort of care did you seek or receive, on what date, and from whom? And so that is a disclosure for payment. That's fine. Healthcare operations is a bit of a broader category. And this may also become relevant as we get into the discussion of AI, because healthcare operations relates to everything else really that's mostly internal, but sometimes can involve external consultants that relate to how the provider organizes itself. So if you're talking about a single physician's office, that's pretty simple. Their operations, they probably have, a couple of doctors, maybe a nurse or some nurse practitioners, mid-levels, a couple of medical assistants, and there's usually a practice manager. Often it's one of the physician's spouses. And so those people can share information when it's for the functioning of the entity. So one example here would be something like scheduling. Okay, they know when patient one is coming in at such time, and patient two is coming in a half hour later, and so that's for operations. They can use that just fine. They can disclose things to people for their operations if somebody's doing an audit or a quality review of them. That's for their own operations, and they can use your data for that. They just can't use it for some other things that we'll get into that are subject to different types of regulation. The main one here I want to point out, because this is a list of those things, those uses and disclosures that do require your authorization. And the number one thing I would put on here is marketing. So I talked about healthcare operations and the things that it includes. It does not include marketing. So if they are sending you a follow-up text to say, okay, you scheduled your appointment for such and such date at such and such time, that's fine. That's not marketing. They're simply reminding you of your appointment. That's a scheduling appointment. If they are saying, hey, remember we talked to you about this service that you could buy from this other party? Well, we're going to send your information over there so they can get in contact with you. That's market because it's not the thing that you originally came to them for, and it's with some other party. So they require your authorization before they can share your information with anyone else. That's the big exception because sometimes people get confused about what's marketing. And sometimes, if they're just putting up a website, they don't need your PHI to do that. Now, if they're going to put a testimonial up and put your picture up there and your name saying they came here and said that the services were great, okay, that's marketing. They're using you for marketing. They need your consent before they can do that. Other provisions of the privacy rule, notice of privacy practices. That's what I was referring to before when I said, there's a big stack of papers in there. And the notice of privacy practice is something that they're required to give you to tell you how the provider is going to use your PHI. And then accounting amendment and access. This has become a big issue over the past couple of years. Individuals whose protected health information you have need to be able to, one, know who has had access to that, when they had access to it, and to be able to change things if there is a problem. And be able to get a copy of their own medical records when they want them. And that's really where a lot of the problems have come, is that providers were putting up a lot of barriers to patients being able to get a copy of their own medical record. Largely, I think, probably for fear that the patient was going to take their medical record and move to another provider. But under HIPAA, you just can't do that at all. What are some examples of privacy health or privacy rule problems? Here are some of the examples. Basically, anytime somebody is using your data in a way that is not covered by an exception that you did not consent to. You know, if you receive a letter in the mail and it's a bill for somebody else's health care, that's a HIPAA breach because now you know that that person went to that, even if it was the same provider you went to, but you've accidentally received it, they put the letter in the wrong envelope, HIPAA breach. Putting things up on social media or websites. I talked about the example of unauthorized staff members accessing the Hollywood hospital example. Right of access is what I was just talking about previously. Providers putting up barriers for not allowing individuals to get copies of their own records. And then lack of training. There is a training requirement that you have to offer training to your staff. If you don't, that is a HIPAA breach. And just briefly here, there was, after the Dobbs decision at the Supreme Court, there was a reproductive health proposed rule, which basically would have limited the ways that providers could share information about an individual's reproductive health with law enforcement. And that's really the primary thing that it accomplished. And the Biden administration proposed that. It never got finalized, and then the Trump administration basically said, we're not going to finalize that rule. We're throwing it out like it's not happening. So I don't think it's worth going into a lot of depth, but that was one thing, just to show you how infrequently it changes. That was the first change to the privacy rule, first meaningful change in 11 years, and it still didn't even go through. So turning now to the security rule, couple key concepts to keep in mind security rule. There are standards, which are identified in the security rule. Big picture things that we are trying to achieve. Then you have implementation specification, which are the discrete actions that you are going to take in order to achieve a standard. And then the rule distinguishes, or at least for the time being does, and we'll come to that a little bit later, between required and addressable. Required is exactly what it sounds like, it means this implementation specification you must comply with. Addressable means you need to look at your systems, figure out what your risks are, and if this risk is present for you, you need to adopt this implementation specification to do this. Means that not everything is required, but it means that some things are going to be calibrated based on your resources, the type of writer you are, what sort of configurations you have, what sort of risks you're subject to, and really tailoring your security compliance to the risks that you actually have. Three types of obligations. Again, these are sort of the categories under the security rule: administrative, technical, and physical. They are sort of what they sound like. Administrative safeguards, things that exist on paper, policies, procedures, the org chart, that's an administrative safeguard. Technical safeguards, the way you configure your systems. You know, are your passwords set to, um, expire after a certain period of time where you have to change them? Do you have user access controls? Those are technical safeguards. Physical safeguards, things like locks on doors. If you have a server and the server is where all the EMR lives, is there a lock on the door? Do you have to go through a lock? Who has the key? Is it a key card? How often do those get, you know, changed? Or, do you take them back from employees when they leave, or could they get access to these things as well? So these are examples I've just included here. We won't go into all of them. Administrative safeguards, you know, standards, and then some of the implementation specifications. There are more, but these are some of the key ones. And I put a particular emphasis here on risk analysis because this is a recurring theme, and I think will be a recurring theme as we get into the discussion of AI, which is you are required under the HIPAA security rule to do an assessment and analysis of your own risks. So if you are a single physician working in one location and you have an office and it's a small town and you don't really interact with any other providers, and you've got a small staff and they've worked with you for 30 years, that's a fairly low level of risk, or in a lot of cases it can be. If you are a hospital system with many sites and many outlying physician offices that refer in, and you have multiple clinics in the community, and you operate in different states, that's a very complex risk profile. And so you are expected to tailor your security compliance to the risks that you actually face. For just the facts that I've given here, the example of the single physician shop sounds like a much lower level of risk than the multi-state hospital system. There are things that can change that, but in general, that would remain true. And so the hospital would expect to have a very sophisticated security posture and would be expected to regularly reevaluate that. Whereas the single physician doc shop, it still has to have some security in place, but not at a level of sophistication as the hospital. And it would only be required to change that risk analysis or conduct a new one when there were changes in the practice's risk profile, which again becomes part of this overall process of risk analysis. Physical safeguards, again, things like physical access controls I mentioned, locks on doors, key card entry, but also how protected health information or data is physically embodied. What happens to that? Is it backed up regularly? So remember the discussion when we were talking about the definitions and how HIPAA regulated not just confidentiality but also integrity. So for example, if you have a system failure in your EMR and your data in your EMR is wiped, do you have a backup? Because otherwise, confidentiality may be fine. If the data is wiped, no one has it. But it's lost integrity because you can't access it. And when you access it, you can't be sure that it hasn't been changed somehow, unless you have backups, unless you dispose of data properly, and address the physical embodiments of the data the same way you would in just viewing it on a screen. And then finally, technical safeguards. Again, it's the way you configure your system. So things like having a unique ID for all your employees, so you know when someone goes into the system and changes the record, there it creates a log which shows who changed this and when. If everyone shares the same login or same ID, there's no way to tell who changed this because it could have been anyone. Encryption, I noted here, encryption has been historically addressable, which means not everyone has to do it. Um, I'll talk a little bit about, recent changes to the rule, but historically, encryption has not been, everyone has to do it because from a resource standpoint, that was often out of reach for a lot of smaller providers. Uh, Problems, risk analysis is also a question on the security side. Cyber attacks, theft of devices. So you've probably heard stories. Oh, there was a nurse. She worked at this clinic, and she had an iPad in her back seat that was from her clinic, and somebody broke the window and stole the iPad. And it turns out the iPad was connected to the EMR. So now not only does the person have this iPad, but now they have access to all the EMR. So, as I mentioned before, there is a rule which came out last year, 2025 proposed rule. It is still proposed and it's not been final. As I said before, there's the distinction between addressable and required. That is largely being eliminated. So now there's no more addressable and required. However, OCR, the Office of Civil Rights within the Department of Health and Human Services, which is the agency that regulates HIPAA and enforces HIPAA, went to great pains to explain, well, the fact that we're eliminating addressable and required doesn't mean that everything is required. It still means that you have to look at it based on your risk analysis and assessment and determine what needs to be done. But instead of you subjectively deciding what do I think ought to be done, we will look at the risk assessment, decide what should have been done, and did you do it? I think the concern here was that addressable was giving people kind of an out to avoid doing some things that they needed to do. And they're like, well, that's just addressable, so I'm not going to do it. Contingency planning is another big theme of the proposed rule. Just this idea that what happens if there's some sort of disaster and you lose access to your EMR and your protected health information? What is the plan to bring that back up? So I talked before about backups. And these contingencies fall into a number of categories. So there are natural disasters. So you lose power because I'm in Houston, we have hurricanes. So we lose power for a while. You can't get your EMR because you can't get power. So what's the plan to get that back up and running? You have to have a generator, what's connected to the generator, what's the priorities. Also, cyber attacks are another contingency. So cyber attacks now don't just take the form of we go in and we steal the data and we remove it. Sometimes in what are called ransomware attacks, they break into the system, they lock it down by changing passwords and security settings, and then they hold it for ransom. So the data has not moved anywhere, at least it doesn't have to. The data is still sitting there, but you can't get it, which again is an integrity problem, not necessarily a confidentiality problem, although it may be both. Annual compliance audits are a new requirement. I think the important distinction here is risk assessment and analysis is sort of forward-looking, looking at what are our risks and how do we need to plan around those to address the risks that we may face in the future. Compliance audits are backwards looking. So what problems did we face and did we react appropriately to those, and make changes that were necessary. Encryption and multi-factor authentication. Um, Multi-factor authentication is going to become more of a standard than simply passwords. When again pointing out that the security rule does not get updated that frequently. Multi-factor authentication was practically unheard of the last time the security rule had a significant rewrite, so now they're bumping this up. And now new technologies. Um, and they identified three. AI is one, virtual reality is one, and augmented reality is the third. And OCR, I mean, it's a bit humorous. They kind of throw up their hands and say, we don't really know what to do here. And the technology is evolving so rapidly that by the time we figure out what to do, the state of the technology will have changed. And so they're looking for, they don't actually propose any rules for these things yet, but they are asking industry and stakeholders for input about what sorts of things should we do, or what things should we look into and evaluate the possibility of doing. So this is sort of a different part and may proceed on a different track because while the 2025 proposed rule was a rule and it had a comment period which is closed now, and so they may proceed with finalizing the rest of this rule. And then the question of the technological piece, the AI, the AR, the VR, may proceed on a different track, saying we're not going to figure this out in 2026. We may figure it out in 2028. But it may be through a different rule or through another rewrite of the privacy and security rule. Breach notification. Very simply, I've only got one slide on this. If the breach affects more than 500 records, you have to notify the people who are involved and OCR and the media. And the OCR, which is the notice that the government saying we've had a breach, must be within 60 days following the breach. If the breach is less than 500 records, you do not have to tell the media. You do have to tell the people who are affected. And you have to tell OCR, but only at the end of the calendar year. So many providers may have a number of very small HIPAA breaches throughout the year. You know, there is one patient who was affected. We accidentally sent one patient's record to the wrong person, and it's just one patient. Well, you don't have to run to OCR within 60 days to tell them about that because you may do that 5 or 6 times during the year. And you can make one report at the end of the year, say, oh, we had a variety of very small breaches, but it really only affected maybe 5 or 10 people. Briefly, I want to touch on some tools. OCR has a security risk assessment tool that is online that you can go, and it will sort of help you conduct your security risk assessment. No, this is on the security side. It is not on the privacy side. It does have limitations. It is not going to conduct it's going to ask you some questions, walk you through some configurations, uh, help you figure out what you need to do. It's not going to run penetration testing on your systems. It's not that sophisticated. So don't think, oh, we're going to use the OCR tool and then all our problems will be solved. This was a former tool. The NIST is just a government agency that conducts sort of standards and creates common standards across government. Again, this is related to security rule. It has not been updated in many years, and they carry a pretty heavy disclaimer on the website now saying we're not updating this and we're not going to update it in the future, so sort of use it at your own peril. It's a little more sophisticated than the OCR security tool, but not that much more. On the privacy side, you have the HIPAA audit protocol. So when HIPAA first rolled out, it was very reactive. You know, people would send in notifications to OCR about incidents that had occurred. And then they would investigate and decide whether they wanted to take action. About 10 or 12 years ago, OCR decided they wanted to be more proactive. And so they created this audit protocol saying, we're just going to pick some random providers and go out and look at their system, see if they're complying. And if they're not, we may punish them. There may be penalties or corrective action plans they have to. But they said, but we're going to send you, we're going to make available to everyone the protocol that we use to conduct the audit so you can do your own audit and figure out where the problems might be. If we come looking later on, you can be prepared. So this is a very useful tool. Again, it's not going to do anything automatically. It's just kind of creating an easier to read version of the regulation so you can hand this to somebody and say, you conduct an internal audit on our HIPAA privacy compliance. Um, these tools, I think I've pointed out, they don't do everything. They're not a guarantee of compliance. They're just an aid. They're not automatically going to come up at the end and say, you are HIPAA compliant. We guarantee it. Um, but if you're starting from zero knowledge, it's a good place to start. So the question comes up, there are a lot of folks out there that sell uh, HIPAA consulting services. And so you may be a provider trying to figure out, do we need to hire one of these people? And so I've given some ideas of when it's a good idea and when it's not. If you've got people in your organization that know this stuff really well and they can competently run a self audit using the tools that I just explained, you're probably fine to not have a consultant. If you don't have any of those things and you're starting from zero and you need a bunch of technical work done and you don't have the personnel to do it, that's when you need to hire somebody from outside. Um, but the final tool that I'll call out is OCR does do enforcement actions, and then they do a little write-up of, you know, what did we do? Why did we go there? What did we find? What was the penalty? You can do yourselves a lot of good by going and reading those and figuring out what is it that OCR cares about. What are the things, the recurring issues that they keep picking up? And I'll tell you, one of them is people aren't doing risk assessments. So you can do a lot of help for yourself just by doing that. And they will often, when OCR goes into a place, they will ding the provider for the breach of the rule and then for not doing a risk assessment, which would have detected the breach of the rule. And those are two different penalties. So you can save yourself at least half the trouble by conducting regular risk assessments. So turning now to some hot issues, this is where we'll get into our discussion of AI. Um, there's no private right of action under HIPAA. So if somebody goes to you and says, I'm going to sue you for violating my HIPAA rights. No, they aren't. They can't. They can go to OCR and complain about it. OCR might do something, but they can't sue you for violating HIPAA because there's no ability for a private individual to enforce that. Cybersecurity and hacking, I've talked about that a number of times. It seems to only be growing. Um, when you see there's really two metrics to look at. One is the number of breaches, which is how many providers suffer a breach, and then how many records. So for example, 2024, there was one breach, Change Healthcare, which I talked about before, which had a huge number of records involved. So even though that's one breach, that's a lot of people's records. The number of breaches seems to be growing. As you see here, from a baseline of 2017, there were double the number of breaches in 2023, and it seems to only be creeping up from there. But they're going after bigger and bigger entities, so that means the number of records is increasing at also a consistent volume. So looking at the new technology question, I want to talk about a couple of uses of AI and how AI would interact with the HIPAA rules. So there are uses out there for AI in managing a practice or in billing or creating medical records for things. And that is an instance where AI would be a business associate because they are using protected health information in order to do things. Now, those uses or disclosures here at the AI platform exists sort of outside of your system, which is covered under treatment payment and healthcare operations, but it is a disclosure to a business associate. The biggest, I guess, attention right now seems to be on decision tools, meaning if the doctor comes in to see you, they're asking you some questions, and it used to be that the doctor was sort of doing a differential diagnosis in their head, trying to figure out, here are your symptoms, here are the things that you're reporting, here are the readings, your weight, your temperature, your blood pressure, etc. So I'm going to figure out, based on my experience and my training, what it is that's going on. And now, to some degree, that's being turned over to AI, and a provider or the provider staff may feed in a bunch of things about symptoms and readings and history, and then the AI sort of comes up with a suggested diagnosis. Now, it's very important how these tools get used because you are giving them access to patients' protected health information. So clearly, there's a HIPAA use and disclosure going on here. But also, these platforms exist outside of your office and your IT system. So it's disclosure to a business associate. You're going to have a business associate agreement which covers what the platform is doing for you. You need to make sure that HIPAA protections are built into those business associate agreements. There is some concern when there is an AI agent accessing medical records of a patient, whether it is for billing or collections, or especially with decision tools, there is some concern that the AI may be adding, deleting, manipulating, revising things in the medical record to add in its findings or changing things to look a certain way to justify a result that it's come up with. And recall the discussion that we've brought up a couple of times about integrity, that you may be fine on the confidentiality side. You may not be fine on the integrity side. If the AI is getting there and tweaking things and changing things, you may not be okay on the integrity side of things. One of the protections here is going to be making sure that the AI system you use is logging and tagging its inputs into the medical record. So I referred to before, there being like a unique ID for someone. So if someone accessed the medical record, then you would be able to tell who changed this and when. Okay, it was, the medical assistant that saw the patient at the front desk, and they were the ones that made this change in the medical record, and they made it yesterday when the patient was in the office. So that's fine. If the AI is in there just changing things, but those changes aren't logged and they're not recorded as coming from AI, that's an integrity problem and a potential HIPAA breach. This is a little bit outside the scope of this conversation today, but one of the other concerns about this sort of use of AI, particularly decision tools, is that the AI is essentially performing the function that the doctor formerly did, and it is practicing medicine without having a medical license. And there are all sorts of restrictions in many states, probably most states, on unlicensed individuals or entities providing professional medical services. One of the things or one of the motivations driving this is if the AI can do the sort of diagnosis and recommended treatment, what do we need these expensive doctors for? We can just have a nurse or a nurse practitioner or a physician assistant or a pharmacist or a chiropractor, someone who is generally speaking much, much less compensated and much easier and quicker to train. Training a new doctor takes a long time. It's very expensive. Uh, Training in some of these other professions is not nearly as expensive or time consuming. So if we can put the AI in their hands, we can make them into a doctor, even though they don't have a medical license. And the unlicensed practicing medicine is at least a civil violation, if not a crime, in most states. So watch out for that as well. The more that the AI is determining what the providers do rather than simply informing them or changing things after the scene. So the billing is a different example because the service has already been provided, the care has already been rendered, the patient is already treated. Now we're just figuring out the bill or the scheduling, which is a little beforehand, but they're not dictating the care. They're just saying person's going to come in at 9 instead of at 9:30. That's fine. Um, One other use that I will mention because I interacted with somebody who was developing this a couple of years ago was using medical records to train AI. So again, we're not even talking about the treatment of a specific patient, but we're just going to feed a bunch of records into AI in order to train it for one of these decision tools. Um, Depending on your relationship with the AI platform, that's a disclosure, and that does not fit in your treatment payment healthcare operations. It's essentially a marketing use or a use that is totally outside of any HIPAA exception or protection. So be very wary of that. Now, one of the examples that I ran into was um, if any of you ever had an endoscope, which is the scope down the throat, or a colonoscopy, which is scope going the other way, um, there are images. It's not just the doctor doing it. The doctor is there watching the screen. The scope has a camera on the end of it. And so there are images and often even videos of sort of the scope going down and then things that doctor identifies. And people were feeding those videos and those images into an AI model to teach the AI how to identify, you know, cancer, polyps, other sort of gastrointestinal problems that you identify using an endoscope. And once that happens, you don't need the doctor there looking at the screen. You can just have, a nurse, a technician sort of do the scoping part and then let the AI find the problems. And again, there's the AI practicing medicine without a license. So it's one thing if the doctor's sitting there and the AI is saying, hey, you should check over here because in a bunch of the cases that were fed into my model, this little image over here was a problem. So the doctor looked at it and says, oh, actually, thanks for pointing that out. That is a problem, or no, that's not. And then that goes to further iterate on the AI model. So it can be useful as an aid, but if the goal is automating it, essentially to render the physician obsolete, that's going to be a problem on, with HIPAA and on a lot of different levels under state law, including. Um, you are probably aware that there are also state laws that are addressing AI and then some controversy with the federal government about to what degree uh, it is going to preempt state laws on AI. So in Texas, we had a rule or a law passed just this past session, which ended in 2025, which said if you are going to use AI in a medical practice, you have to disclose that to patients. You have to tell patients, look, we're using AI, and tell them what, okay, we use AI to help us with scheduling. We hope AI to use us with billing. We use AI to, as a decision tree or, in such and such ways. And then you have to be able to identify what records the AI is creating for that patient. And those records have to be flagged and reviewed by the doctor in all instances. So if the AI comes up with, the model reviewed that colonoscopy video and identified a certain, the physician has to actually look at that to make determination. You can't just let the AI make decisions. So that's Texas pulling back a little bit on that. The other requirement that came in with that law is that all electronic health records or medical records for patients in Texas have to be kept within the United States. So that's also, while the United States and the states are thinking about AI regulations, other countries regulate them differently. And could they be feeding medical records into their AI models to inform those, even if those technologies will not ultimately be available in the United States? And Texas said no. If it's an EMR, doesn't have to stay in Texas, but it has to stay within the United States. So I think there's a lot of interesting things to say about, you know, AI and its potential uses. Almost all of them that I can think of address, the question of, what medical record use is being made here, and is it being disclosed, and is it going to help just this patient, or is the AI going to take it and use it to other patients, and is that transparent to the people using it? It's one thing to say, I can do an audit log and figure out where my medical record is used. But once it goes to the AI, I can disclose, okay, this medical record was put into this AI model to help it learn. But then how many times does the AI use it? And does every one of those count as a disclosure, or does it learn it once and then it's done? Or is it going back and consulting it multiple times? And that's probably a program and engineering question that's way beyond me, but it presents question. I think that's some of what OCR's puzzlement with this is we don't know what to do with this because the uses are evolving so quickly that as soon as we make a rule, that use is falling out of favor, and now we're on to the next thing. Just briefly on VR and AR, this discussion doesn't come up as much, and I get the sense that while OCR is still a bit in the dark on what the uses for these will be, the use is primarily in behavioral health or therapy settings. So, if someone wants to, is going to a therapist for some treatment of a mental health disorder and they want to put on, a virtual reality, goggles or headset or something to help them imagine a scenario that is useful in their therapy. That's a use. Augmented reality, same thing. Well, can we imagine if, you know, the following things were present with this help in your therapy or help eliminate certain traumatic triggers from your life, through the use of augmented reality. So it's more in a mental health setting. And so it's interesting to see how that will evolve, particularly because at least here in Texas and under HIPAA, certain mental health records are given an even higher level of protection than just, the records of your open heart surgery because they record your inner thoughts. And we've created this sort of dichotomy where, a person's inner thoughts and feelings, and then the therapist's impression of those thoughts and feelings and the conclusions they're drawing are somehow more worthy of protection than sort of just a picture of what's going on inside your body. And with that, I'll conclude. This is my information to contact me if anyone has further questions. This is an area we're thinking about every day. I've got colleagues down the hall that think about this all the time. So we're very excited to, see where the technologies go. And if folks have questions, I'd be happy to talk about this further. So thank you for your time.
Awesome. Thank you so much, Adam. And thank you all for attending, those viewing live here and those who are going to watch us on demand in the future. If you have any questions about HIPAA, reach out to Adam. He's the expert on this topic. So thank you all for attending the Watch You Law AI Policy Series. Thank you, Adam, and have a great rest of the day.